It's very rare you get a chance to talk to a major league probate attorney. Today, we literally have a certified with a fancy logo over his shoulder, major league probate attorney from San Diego, California, repeat guest here on Probate Weekly, Zach Whitman. Zach, thanks so much for coming back to our show.
Thanks for having me.
And fresh off the plane from Scotland and London, so we appreciate you flying all across the world just to be here with us today.
I had to rush back because I didn't want to miss it.
Well, thanks so much. So let's talk a little bit of kind of guess the groundwork on your firm. You're in San Diego. You work for Antonio and Miranda. You're an attorney there. You guys are a big firm with a broader base of business. You personally, describe for me where your focus is: probate administration, probate litigation, estate planning, all three. One of those. Where do you really focus your time?
Yeah, so for me, I started originally as an estate planner. That was the primary purpose of my practice. After I left corporate law, so I was doing mergers, acquisitions before coming down to San Diego. I started in estate planning, then started dabbling in some probate admins. Now my practice is 95% probate litigation, almost exclusively litigation. I am the sole estate planner within our firm. It's not a huge part of our business. Most of our estate planning is for existing divorce clients. For our firm started and is known as a divorce firm first and foremost. So we do estate planning for our existing divorce clients. We will do estate plans otherwise, but 95% of our business is true probate litigation, contested matters, capacity cases, undue influence, the whole gamut of litigation.
So there's a wide variety of what that looks like when you say probate litigation. And I don't think it's so often I'll be in a chat room with somebody, or I have a Facebook group and people say, well, I need an attorney. What do you need him to do? Oh, well, I have a question about the fence. Well, that's a different attorney than, I stand to inherit, $500,000 and there's somebody who claims to be my brother who's not. Those are two different worlds. Or somebody signed my mother to a quitclaim deed while she's on her deathbed. So describe kind of, if you could, give me the pie chart of what the cases look like in your litigation practice. How much of that is elder law or elder law abuse, or versus two beneficiaries fighting over who gets to be the administrator of the probate?
Yeah, it's pretty evenly split, I would say. Probably a third of our case makeup is beneficiary representation for breach of fiduciary duty type cases, so embezzlement or mishandling of trust funds. Another third is invalidating type cases where we're seeking to invalidate a trust or a will. Another third is probably just kind of generally contested probate administration. So intestate succession, but trying to oppose the appointment, or who's going to run the estate, or issues within the estate administration. We don't do a whole lot of trust defense work, though we would like to do more. That's the better side of the case to typically be on financially, but for the most part, our cases tend to make up being the beneficiary representation.
Well, I'll give you a little business hint. If you write worse trusts, you'll be in more litigation on those trusts.
Sure, yeah.
Okay, so let's cover from the top. Beneficiary representation. Somebody's passed and another person thinks they're due money, and all of a sudden somebody is running the probate, and they'll say, hey, there was a house and there's money, it's disappeared, or there's a bank account or two, and they disappeared. So what can a prospective beneficiary do? It's expensive to hire an attorney, right? So what are kind of the parameters, and what's the case kind of look like that gets you involved?
So a beneficiary has a lot of rights and a lot of authority within a trust for information and accountings and disclosures. So the position of trustee is kind of a lose-lose situation, to be candid. If you're a trustee, you're only going to fail. You can't really succeed. You can do satisfactory or do it poorly. There's not a great trustee. You just have done the job properly. So a beneficiary who has questions of the trustee's actions, they have a lot of rights in probate court for accountings and disclosures. So the main goal is to hold the trustee accountable for what they're doing, what they've done with the trust money, and it changes depending on when they became trustees. Some trustees become trustee before the elder has passed away. if there's an issue of capacity, they could become trustee long before the person passes. And the duties to the beneficiaries date back to the day they became the trustee. So what we see a lot of is long-lasting trusts that maybe were not the best drafted trusts that have 5, 10 years of required administration. And that's a lot of information that a beneficiary is owed. And maybe they're not getting it, or maybe what they're getting from the trustee is deficient. So we go to court and get court orders for disclosures and accountings. And then we start picking apart the actions of the trustee to see where maybe they fell short. And if they dip their hand in the pocket a little bit here and there, then we'll hold them accountable under the probate code and try to claw back the funds and penalize the trustee above and beyond. So that's kind of the general approach.
What's the requirement for disclosure of a trust and or the provisions of a trust to a beneficiary? I get a common case I get, and I'm sure other realtors get, is somebody suspects they should be inheriting their child or their whatever next in line, and they know so-and-so passed 3 months ago, 4 months ago, and the bad guy has the trust. He's not disclosing anything. They suspect he's raiding their bank accounts. So I know that I believe there's a code that they're required in California to disclose to beneficiaries the existence of a trust and the general provisions. What are those disclosure requirements in California?
Yeah, so once the trust is being administered, the trustee owes duties, annually accountings. The terms of the trust can change the responsibilities. They can shorten the deadlines under the terms of the trust. Generally, if you demand an information from a trustee, that's usually about a 60-day required waiting period for the produce of records and accountings and whatnot. You can sometimes get that shortened by the court if there's exigent circumstances or reason you don't trust the trustee, or they're swiftly taking action. The property's on market. They're taking it to market, and you can go in ex parte or shorten time to not wait the full 60 days of following your request for information. But usually it's 6 months or a year is usually the routine required reporting, unless you demand otherwise. And if you demand otherwise and have a good basis for a demand, they usually have about 60 days to respond. If they don't respond within that time frame, you feel free to run over to the probate court and ask them for that.
Ask for some help on that.
Yeah.
So you should be notified if you otherwise would inherit in a probate, meaning if they pass intestate and you're the next of kin or one of the next, they should be notifying you. Would they affirmatively have an obligation to notify you, or do you have the obligation to request it and then wait the 60 days?
Industry norm versus probate code is a little different on that. You're required to deposit the will with the probate court within, I think it's 6 months. But that doesn't happen very often.
Right.
Maybe there's a trust and there's no reason to deposit the will, so you don't want to go through that process of opening a probate administration.
Right.
So you kind of just shrug your shoulders at the probate code without that situation. But in my practice on trust administration, the first thing I'm doing is sending a 1606 1.7 notice, a trustee notice under the probate code, to all beneficiaries and intestate heirs, whether you're a named beneficiary or not. That starts the timeline to challenge the validity of the trust. So that's a 120-day challenge deadline. Pretty common practice is as soon as you're retained for trust administration, you're sending out that trustee notice that contains a copy of the trust and what rights you may or may not have under it.
So just to go back on that again, so you're sending out a copy of the trust to all the parties who either are or would normally be beneficiaries of the estate, a copy of the trust, and then you give them a timeline by which they can object. If you don't do that, then that timeline hasn't started yet. So theoretically, if they don't give you a copy of it 6 months later and you reach out for it, your timeline starts at that time.
Right. So you're not barred from challenging the validity of the trust document until your probate code 1606 1.7 trust notice deadline has passed.
Got it.
So I've had a few cases where I get retained 6 months, a year after the person passed away, the original trustee trustor passed away, and they say, well, we're good. They've spent 6 months or a year. There are a lot of statute of limitations for 1 year after the date of death to make claims against the estate. But to challenge the validity of the trust document, if you haven't got your 1606 1.7 notice, your 120-day deadline to challenge that has not yet run. So you may still have an opportunity to invalidate the trust document.
Just a quick housekeeping. This is Probate Weekly. We do this every Thursday, 4 p.m. live Pacific time, 7 p.m. Eastern. We live stream it on YouTube, Facebook, and LinkedIn. If you're watching on the live streams, feel free to put your comments there, and I'll do my best to bring you in and answer them along the way. If you want to sign up for the Zoom, go to probateweekly.com. Love to have you come in. Number one, feel free to network. I see Mark Pedroza. Put your name, contact info, where you do business, what you're looking for, and let's all do some business together. And then if you have questions as well, either raise your hand or put in the chat box. I'll try to catch there and participate. I'll warn you, Zach and I have had a few conversations, so I could do this for a couple hours. I'm going to ask a lot of questions. If you guys don't raise your hand and jump in, and I think this call today is more technical because we're fortunate to have somebody who really is an expert and a practitioner in the litigation and some of these details. So, buckle your seatbelts if you're a little concerned about some of the detail. I'll do my best to capture any jargon, and if I miss a word that you don't understand, please feel free to put it in the chat box to ask me to go back and catch that. While I have you on the call, so again, Probate Weekly is the call, and then separately, we have a Facebook group. If you want to continue the conversation there, we'd love to have you do that. That's Facebook's Probate Weekly is the name of the Facebook group. We have 3,300 members there. You can ask questions there. You can put referrals for attorneys, looking for referrals for real estate agents, as well as post your probate content. And we love to have that content shared both for us to learn as well as to help you get some views and some Google love and some Facebook love. And then my information, linktr.ee/Bill Gross has all things I'm working on. And upcoming, I have on November 15th, a week from yesterday, email mastermind class. The program is focused on getting your email database together to drive your business and marketing and such. And so feel free to check that out if you want to. It's on the link tree. There's the email mastermind class. I'd love to have you guys join us. $97. And there's a promo code if you're with the eXp Realty as well. And then lastly, our guest today, Zach Whitman, is with Antonio and Miranda, which is a really big law firm real-known law firm in San Diego. They do a lot of divorce. They're probably best known for divorce. But I came across Zach on a case a couple years ago, and I just really found him to be a great resource to teach us along the way about the probate. And he's been very generous to join in there. So thank you again, Zach, for joining us. Okay. So we talked a little bit about notification such. I recently had a case actually in San Diego where I was the fiduciary. I was the administrator of a probate, and most people know there's a statutory limit for fees for attorneys that they get paid, and there's a formula for that, and the exact same formula actually for the administrator of the state if it's not provided for. In a trust, do trusts normally provide for fees, or is there similarly a statute that guides the compensation of the trustee?
The trust language will control that. So the trust, I would say probably the most litigated term in all trust litigation is the term reasonable compensation. And what is reasonable compensation for a trustee very much depends on the qualifications of the trustee. If you are a layperson acting as trustee, you're not entitled to the same level of compensation as a bank. If Wells Fargo is acting as trustee versus Joe Schmo down the street, they're not going to get the same compensation.
Interesting.
So a lot of the trust I draft, I do not use the term reasonable compensation because it's going to result in litigation. Right. What you normally do, you look to the published trust compensation schedule from the corporate trustees, the banks. They publish their annual compensation that they require from a trust. And I put that if you are not a corporate trustee, you get half the compensation, which usually amounts to between 0.5% and 1% of the value of the trust administration on an annual basis. So if you're running $1 million estate annually, you can do the math from there, and that's what you get on an annual basis. So it's very different compensation than the probate administration, which is statutory fee based on the sliding scale of valuations, fair market valuations of the assets you're probating. So trust compensation is significantly.
That probably explains why fiduciaries are so into licenses and titles and certification. Like their signature line has like 15 different initials after it because they are, maybe properly demonstrating their expertise, maybe as an attorney and a realtor and an accountant and a this and a that, and therefore they're able to defend a higher fee than a layperson. I guess that's what that's about.
Exactly. So if the trustee fiduciary acting can show they're a licensed bonded fiduciary, they're entitled to higher compensation than if they can't.
But still debatable as to what's customary, I guess, right?
But usually county specific. In San Diego, for a professional, you're looking at probably 3/4 to 1% a year, maybe up to 1.5 if they had to do extraordinary measures. If it was a really complicated administration, they may be able to ask the court for instructions for higher compensation. But usually that 1% for a professional and a half for a layperson is pretty standard.
And so that's pretty much in line with, excuse me, a bank that, or let's say a wealth management company that buys you stocks, bonds, and different investment vehicles, and they may negotiate the lowest commissions or not charge you commissions, but then charge you a management fee of 0.5% to 1%. That's kind of the thought behind it. How about when the trust involves disposing of assets like real estate in particular? Do they get higher fees for that, or extra charges for that, or?
They can. It depends on if it's being litigated. So if it's a non-litigated trust administration, they can put a higher figure, and as long as a beneficiary is not opposing of it, it can get through. It's not court supervised. So that's the variable. If it's a court supervised administration and they have to take extraordinary measures, they're going to be filing a petition for instructions with the court to approve their compensation. And then the beneficiaries will have their day in court to oppose it. And ultimately, the court will rule on what's reasonable compensation for the trustee and the trustee's attorney.
And can trustees also serve other capacities like a real estate agent and collect normal real estate agent fees, or accountant and charge normal accountant fees or legal fees? And
it's I would say it's a bad idea because it's only going to give the litigator more ammunition.
right.
I recently had a case where the attorney was also a licensed real estate agent that forego some trustee attorney representation compensation for their real estate commission. And I did not find them to be a qualified real estate agent because their primary practice is law. I don't pretend to know I can market a property better than a real estate agent. And when they fell out of escrow 3 or 4 times and sold it for $50,000 under asking. I use that as ammunition in the probate court to say, cut their fees even lower. It shows how unqualified they were versus how qualified they were, and
Ouch.
I got them removed. So it's probably a bad idea unless you're exceptionally good at your job to be wearing multiple hats.
Yeah.
Trust administrations are inherently complicated, and adding more variables to it is only going to cause more problems. So I would generally say probably a bad idea, but not ethically prohibited.
And I think when I meet fiduciaries who act as both, I always feel like I probably don't want to work with them because they're kind of saying to me they're maximizing their compensation maybe at the expense of the customer or client, and that's not normally going to work in the long run. So I have to stay away. So let's talk about those people, though. Those fiduciaries are people who would hire attorneys once something goes into litigation. So imagine for you that those are prospective customers. They're both victims or not victims. They're the objects of your litigation. And then
Yeah.
on the flip side, they would be, I think, prospective customers hiring you to protect them or defend them in those cases as well, correct?
Correct. Yeah, that's kind of the whale for us, really. If we can get in with a high level professional fiduciary and be their go-to, that would be a very good revenue source for us as the attorneys. The most common situation is when you're attacking a layperson, a family member trustee for their malfeasance. The first thing you're going to do is ask the court to remove them and put in a professional fiduciary. So they're not necessarily the direct target. They inherit the mess, and then they just sit on the nest egg making out routine distributions or distributions pursuant to court order. They also retain counsel, though. They retain representation that appears in court or mediations and depositions. And that, to begin, that's the kind of the dream for us trust litigators to just sit and watch the fight from afar and hit
Right.
easy billables. But we don't do a whole lot of that here. We want to be on the beneficiary side or the trust side in the fight. We like the fight. It's kind of what our firm is known for, is we don't shy away from litigation. We don't shy away from trial, where a lot of attorneys don't want to do the trial. They'll get up to the eve of trial and they'll bring a trial counsel. We don't. We want to take trials here. We want to be trial attorneys. So that's kind of what distinguishes us a little bit, and why we don't represent trustees as often, because we want to be in the fight and instead of watching the fight from the sidelines.
So I often get, because I'm active in real estate, and I'm sure people on the call, real estate agents as well, get the phone call. Hey, my aunt passed or my mom passed, and I'm one of 3 or 4 siblings, and so my brother is cheating, blah blah blah, and it might not be enough equity in the property to generate revenue, or they may not have the money. So, what kind of is a guideline that somebody should bring to a law firm? Let's say your law firm. What would become is there a minimum equity at issue, or is there a minimum amount of money up front that they have to be able to fund? Because I'm sure litigating a case can cost cash wise a couple $100,000 in the blink of an eye, I would think.
It could. There's not really a hard bottom line for us. The ultimate question is, how much is the fight worth it? If $100,000 is more than you're going to inherit, logically maybe doesn't make sense to be in the fight. But if the fight's not about the finances and it's more about the vendetta, that's not uncommon in probate, that it's really about childhood grievances and less about the inheritance. They may be willing to zero out their inheritance to stick it to their brother, and that's fine by me if you want. But the issue with probate administration versus trust administration, probate administration statutory fees are based on fair market value, not the equity. So if you have $1 million property that's fully leveraged at 900,000, the statutory fees is not based off the $100,000 equity. It's based off the $1 million fair market value.
Right.
And that's why the property ends up having to be liquidated 9 times out of 10 to cover the statutory fees. If there's not $30,000 of equity, then we have to liquidate. We have to find the funds to pay the attorney's fees, which almost always comes from what equity is in the property.
Right.
Trust administration maybe is very different. Maybe we don't care about the equity, or maybe we care about it more. Depends on what the ultimate goal of the client is. Is it vengeance or inheritance?
And often trust administration, really the goal is just to kind of manage the pipeline of money and keep it, evenly distributed, and keep those checks going for all the family members. It's not the same goal. Whereas probate by its nature is a one-time event, right? They're trying to close it out quickly and efficiently, and trusts are often designed to be for a longer period of time, I guess.
Yeah, I actually got scolded by one of our probate judges not too long ago for effectively the quote was, "You don't rent properties in probate administration." We had a rental property. We were continuing to rent the property to increase the cash on hand for the estate to pay fees. And she goes, "No, you have to sell this house. You have to get moving. I'm going to start penalizing you and sanctioning you for not administering the estate." And in a trust, that maybe is the perfect option, is to continue to rent it until there's enough cash on hand.
Right.
But in probate administration, the point is to efficiently move that estate through to final distribution. If liquidating the main asset or all the assets is required, then it's required. The trust, maybe the purpose of the trust is longevity. Maybe the purpose of the trust is a dynasty trust to provide for generations of family to come. And then you have ongoing administration. That's very different from probate, where they want you to push it through, get it done, and get it distributed. Because the longer it's not, the longer it's on the court's docket, and the more cases and the more bogged down the system is.
The judge does not want that case on the clock. Keep the thing moving. Stay out of the way. It's a train going downhill for sure.
Yeah.
But just to clarify, when you say not rental and probate, one of the heirs can buy out the others and keep the property and rent it. They just have to dispose of the property from the estate, but the heirs can do whatever they want with it if they're able to afford that.
Sure. If they have cash, like they can buy out the other side's inheritance, or fully fund the reserve. That's a part of the problem as well, is funding the reserve, paying the fees.
Right.
If there's debts of the estate that need to be satisfied, you may be coming up with more than you expect. But if they want to get the property, there are certainly options and ways to keep the property. You just got to have the cash for it.
Right. Well, and I would just say, FYI, I finance those too. I do trust to probate estates to flip the property, temporarily, and then they refinance it in the name of the heir ultimately. So we can do it without cash. I've done those, a few of those actually, and it's convenient for the customer because they don't have the cash, but they want to keep the property. It might be a great rental for whatever reason, or they just want to keep it. So just kind of put that out to everybody in the call. So let's move a little bit. One of
Yeah,
the other top. Oh,
still
sorry.
cash. It just doesn't matter to me where it comes from.
Exactly.
Yeah.
At all. Doesn't matter to you at all.
No, not one bit. Yeah.
As long as deposits, we transfer title, and the judge doesn't care as long as that probate closes out. They just want those cases moving. Do not get in the way of the judge and the case, man. That's the one place you never want to be. I used to go to court every day pre-COVID, and even now I go once in a while, and you'll see people propose things that delay things. And you can just see the judge, like steam comes out of their ear. They do not want things held up. That's number one.
Well, and that's a great opportunity for an attorney to be creative. And
Right.
if you can be creative and come up, if there's a stalemate that's going to end up in a trial on some issue, if you can give the judge an option, do at least do this part, they're going to side with you. They're going to think, hey, you're being useful to me, versus the other side, which is just wants to continue to litigate.
Right.
And that's where I've found great success in special administration. If
Right.
you can, if you need to liquidate the property, but you're going to ultimately fight over distribution, well, let's liquidate it under special administration while we wait for a trial date on distribution. So that's a great way to be creative. As long as you're giving the judge an option to make advancement, they're gonna favor you.
So let's talk about that because that is a great solution that probate. What's the word again? Major league probate attorneys, not your average attorney, but major league probate attorneys, use as appropriate regularly. And I find that the attorneys that dabble in probate never think about. I literally just got a phone call for a referral where it's a limited authority and there is a little bit of an issue, but really it's a solvable issue. You can make it full authority if you just do a couple of things. The same with special administration, that you can have both sides wanting to kill each other literally, but there's no reason to keep the property in the middle. You can find some way to get the property, appoint somebody special administrator, agree on who the realtor is. The money all goes into a blocked account or whatever form you want. Get the property sold so there's no more mortgage payments, taxes, squatters, and risks. And that's a solution that I think, again, the major league probate attorneys know, and the minor league ones just don't even think about.
Yeah, it's. I'm seeing more people do it now. I wish that I'd like them to stop so I can keep it to myself. But it, it is becoming more acceptable in probate, at least in San Diego. Most of our cases are in San Diego County. So it's becoming a more acceptable principle with the judges here. We've had a turnover in judges since the last time I was on here. We have 3 relatively new probate judges in San Diego, which is unheard of. We had Judge Bostwick and Judge Kennedy that were with probate for 16, 17 years in San Diego. So they were set in their ways, but we have 3 new judges that are a little bit more receptive to creativity. And that's a great time to be creative and sell the property, blocked account or holding escrows for the funds while we continue to litigate is a great option.
Yeah, I think so for sure. So that's definitely one. And for the realtors of the call, something you might want to talk about the attorney if they don't know about for sure, or refer your customer to a major league probate attorney instead of a minor league probate attorney. Let's shift a little bit to another area of litigation, which is invalidating the trust or will. The most common case that comes to mind to me is elderly parent, caregiver, or elderly parent in some sort of a home situation, and the bad son or daughter coming in and get something signed that changes the whole ball game. They had a trust, now it's out of the trust, or they had a will that distributed evenly. Now everything goes to the beloved child that took care of the kid all along. Do you get those kind of cases, and what's the common case story look like?
Yeah, we get a lot of those. Unfortunately, the caregiver case is far too common. And my speculation is the next 3 to 5 years, it's only going to increase as we see what happened during the COVID lockdown. The issues of what happened during COVID and the pandemic, and what changes to documents an elder may be made during the last 3 years, I think is going to be very prevalent for the next 3 to 5 years. That's going to be a very common fact pattern. But yeah, we have a lot of caregiver cases where the caregiver is received the full or significant portion of the trust distribution through a late in life change that's a questionable either capacity or undue influence. Thankfully, the presumption is against the caregiver. So if a caregiver is the primary beneficiary of a trust where they receive caregiving payment for caregiving services, the presumption is it was the product of undue influence and is generally invalidatable, avoidable through challenge. But again, you have to challenge it within the proper deadlines. If you've been served a trustee notice, a certificate of independent review can change that presumption significantly. But yeah, that's probably the most common is a caregiver receiving. The second most common is a relatively estranged child that came back into their life and all of a sudden is now the primary beneficiary of the trust document or the will is also very common.
So what are, I guess the first question I would ask is, what are flags? The obvious flag is a lack of a relationship, consistency, and if they're getting paid as a caregiver, those would be obvious flags. Are there any other obvious flags or fact patterns that kind of raise your antennas and say this one becomes easier to attack?
I mean, significant changes is a very big red flag. Most people are pretty set in their ways, especially if you're in your 60s, 70s, 80s. You're pretty steadfast in your beliefs at that point. And it's pretty uncommon for a child to be fully disinherited. The moral sense of parenthood, typically they want to still provide for the estranged child. So if they're fully disinherited, there's a reason. There's something happened in their life, or there's a basis for that. And if they've come back in without some form of intervention or some family regathering, that's going to be pretty questionable and give a good basis for a challenge. If you've been fully disinherited and you're back in, the family will either know why in a good way or a bad way.
What are, and I had a case where I had an elderly family member who was living on her own with a caregiver. And we've had a couple of bad experiences in our family with caregivers where relatively minor embezzlement, relatively speaking, it's all relative unless it's your money. But at least I was checking the public records every 30 days to see if there's any documents filed. That's one thing that I do because it was my aunt in this case. What are good practices to protect an elderly family member from, or whether it be your parent, protecting your inheritance and or protecting a family member where you're concerned about them being taken advantage of?
I think just routine contact. Stay in touch with your family. Stay in touch with your parents, your grandparents. If there's somebody new in their life, they're likely to be telling you about it. They're going to be telling you stories. They're going to be telling you about this person. And if you have questions about them, start checking on them. But a concept I talk a lot about is what I would consider the expectation of inheritance. You mentioned protecting your inheritance. Well, it's not yours until it's yours. And so the presumption is that everybody has capacity and it's their decisions. And that's the starting point is the trust or will. That's their decision. If you're not getting it, SOL, it's not really your place. It's their decision. As long as it was truly their decision. If it has been their mind has been superseded or usurped by the other person, that's the situation we're worried about. But if it's truly their decision, it's not yours. It's their it's their estate, their hard work. I don't know. I have a
No, I agree with you. In fact, in this case, it's funny because I use that verbiage, and it turned out it was an aunt that, for all I knew, did disinherit me. I didn't really care. I cared that she not have her inheritance taken because she was using the money to provide for herself, and she was otherwise defenseless as she got older. And we noticed things around the house. We noticed things. Her car had damage that the caregiver was allowing her to drive when she clearly shouldn't have been, and some other things that we were just concerned about her safety and well-being. But you're 100% right. Who knows until you get the actual document opened up, you never know what's
That's
yours.
a great situation to explore conservatorship. So while
Right.
the elders living and they're declining,
Right.
maybe they need some help. That's an opportunity to explore conservatorship. And maybe they have testamentary documents that are sound and justifiable. And then you can't get a conservatorship because it's not the least restrictive means, or it's a very carefully tailored conservatorship. But if you're worried about an elder while they're living, the conservatorships are a great avenue to investigate and explore and hold things accountable while they're living. And then once they pass away and all the documents come to light, well, then we reassess and see what we need to do from there. But a conservatorship, Britney Spears obviously changed a lot of that conversation quite a bit, but the probate conservatorship of an elder is can be pretty straightforward if there truly is a lack of capacity and they need help.
Right. So let's move a little bit to kind of general probate administration when you have contests, I guess, where maybe you have multiple siblings filing petitions to be the administrator of the court. Now, you're licensed in California exclusively?
Exclusively California.
Okay. So from a California law point of view, is there a presumption for which of the siblings? Does the older sibling have a priority? Is it, of course, in-state versus out-of-state residence would be an issue. Criminal background might be an issue. What are the general issues as far as determining priority? Who's going to be approved by the court to be the administrator?
If we're all upstanding citizens and on the same generational level, it's going to be who can make the most compelling argument. It's not, there is no seniority and age that matters. We favor in-state residents versus out-state residents, but it's not a conclusive decision, but it affects the bond requirements to an extent. But the next generation, so children before grandchildren, there's a priority for children before grandchildren. If you have a criminal background or have bankruptcies, you're probably not going to get appointed to run the estate because you have fiduciary duties. So if the court's going to be worried about you absconding with funds or you cannot get bonded, you're going to lose that fight 10 out of 10 against your sibling that has a upstanding record and is a senator or whatever we want to say. Is it's going to be what is your background and ability to manage money and how honest are you and trustworthy. But ultimately, that's a triable decision. You can have an evidentiary trial on which of the siblings should run the estate. And that's, to me, a gross waste of time and money to fight that all the way to a trial, because it's gonna take you a year to get to that point to just have a court decide which of your two siblings is actually going to run the estate. That's a great time to consider a fiduciary and a great time to just agree to a neutral fiduciary to run the estate. You said and just collect your money. But that's a very enjoyable fight for me. I have a couple of those cases that I truly enjoy the fight on our end, but it's not usually in the probate's best interest to continue that fight long term.
By definition, because of your law firm and the business you do, you're going to get more of the gloves are off and we're going to war probate battles. But on the normal probate, so and so files, they don't know if the other sibling is, the other sibling does, they can't come to agreement. I see regularly where maybe one of the attorneys will be the fiduciary, the other attorney will be the attorney of record. That way they're both kind of getting the fees and they kind of work together and protect their customer. Is that a good solution? I mean, both attorneys get some money out of it. Is that a good solution for the estate and for the court?
It could be. The good solution for the estate is whatever makes the most progress, whatever gets you to final distribution sooner. If it's going to be a fight for appointment, whatever option you can get is going to be better than no option. If that's an arrangement the attorneys can come to share the fees and both attorneys are happy with that, I don't see a negative way to that. Maybe I've burned too many bridges with my fellow attorneys in San Diego. I probably wouldn't do it. But our firm also isn't. We don't do statutory administration, so that's not part of our business model here. But I could see it working with some other colleagues for sure.
Again, when they've hired you, they've already made the decision that they want to litigate. But with other attorneys, they've hired them to file. And so that's a way to solve the issue is get them to come to some agreement. If they don't, then they should give you a call and litigate. And that becomes a different path.
Yeah, exactly.
Okay, good. Hey, this has been I've enjoyed and I've learned a lot. Hope you guys are as well. And I know we're going a little bit in the weeds here, but Zach is a major league probate attorney. In fact, over his shoulder, you see the logo. That's the official logo. It's actually their firm. It's like a marketing piece, right? Tell me about your marketing and what the MLP and the ML, I think D is the other one you guys do too, right?
Yeah, so that's all the brainchild of Tim Miranda, one of our founding partners. He does all of our marketing. We're very well known for our billboards, our billboard marketing in San Diego. We've actually just opened a new office in Newport Beach. So we
Oh,
have a
wow.
brick and mortar in Newport Beach. We're expanding up into Orange County and then hopefully up into LA County. So those folks driving around in Newport Beach, Irvine area, keep an eye out for some of our new billboards up there. That's our latest right now is Major League Probate, Major League Divorce. We hold ourselves to high standards and are ready for the big league fight versus maybe not so much. So yeah, but Tim Miranda does all of our marketing. He's been running our billboards and our digital marketing for a long time.
How fun. And again, just to do some quick housekeeping where we are, this is Probate Weekly. We do this every Thursday, 4 p.m. Pacific, 7 p.m. Eastern. If you want to join live on the Zoom, love to have you guys ask questions or just raise your hand or put in the chat box. And then also make sure you put in your networking information. We have real estate agents and attorneys and vendors across the country on the call. Love to have you guys participate. You can join the Zoom at probateweekly.com. Or you can watch the live stream, YouTube. You go to episodes.probateweekly.com and you can see the past episodes and subscribe and such. And then you can continue the conversation on Facebook. We have a Facebook group designed for referrals, for attorneys, for looking for attorneys, looking for realtors in other states. Also posting your probate content. Here's a good friend of ours, Courtney Rollins, who's in the North Carolina market. And he posts his YouTubes here, both to inform us, I like watching them, as well as he gets more views on his content. So if you're trying to build your market, don't post just listed and just sold and regular real estate. Make this probate related, but love to help you build your social media strategy as you build it out. My information is all available on my link tree, linktr.ee/Bill Gross. You can see what I'm up to there, different programs. In a week from yesterday, on the 15th, I'm going to do my email mastermind class again, and that's a fairly cost-effective $97 for an hour, and then 4 half-hour follow-ups on building your marketing through using email, which is very fundamental. But I do this class for my team and wanted to share that. And then again, our guest today, really fortunate to have Zach Whitman from Antonia and Miranda, a very successful, well-known firm in San Diego. Family laws are focused and divorce, but his specialty, as you can hear quite clearly, is probate litigation and estate litigation. We're really lucky to have him, and feel free to reach out to him and his firm for those appropriate cases. So let's talk a little bit about the kind of business side. You mentioned that at your firm you have somebody who does that. So do they also look out for your book of business, and then you're just an attorney and the cases kind of come in that the firm is creating for you? Do you have a personal role in your marketing or social media, or do you just focus on the actual litigation part?
Yeah, so Tim kind of runs.
You're here on this call, so you do something, right?
Promote my personal self, but from a firm perspective, the marketing is what it is. I maybe get my opinions asked every now and then, but for the most part, it's Tim Miranda running that. We vet through the clients through me. I'm the managing attorney of the probate department. We have 5 attorneys in our department right now, hoping to grow to about 10. Hopefully by mid next year, we should have 10 full-time probate litigation attorneys in our department. So we're rapidly growing in probate. But yeah, I like the network. I like to market. So folks on here, give me a call. I'm glad to talk shop. But our social media and the firm itself is run by Tim.
And so when you say you're hiring more attorneys, are you looking for acquiring attorneys to have a book of business, or are you more looking for attorneys to handle your caseload that you guys have enough already?
Well, a little bit of both. I mean, I'm not we're looking for talent is what we're really looking for. So if a good quality attorney who's ready to litigate, because that's what we do, we're litigators. I can take an estate planner and help them learn litigation. I can help a litigator learn how to estate plan. We have really good attorneys here, senior attorneys, qualified attorneys that can help train. So yeah, we're not opposed to anybody looking to make their mark in probate litigation in Southern California, and as we continue to expand northward.
If now, not that you are, but if you had a nephew or a family member starting in real estate, and they were interested in probate or working with attorneys, networking with attorneys for business, how would you? I know you must get solicited, and there's a million realtors that cold call and do kinds of crazy stuff. How would you recommend somebody that you wanted to help or mentor? How would you recommend them to build their business development to both learn this niche as well as to build their business or book a business in this area?
Yeah, I think the place I would start first and foremost is a really good title company.
Mm.
Knowing title, understanding vesting, and having a true grasp of what type of title issues will result in probate is a big deal. That's a good way to set yourself apart as a real estate agent, truly understanding a right of survivorship, joint tenancy, what to look for on a deed
Mm.
that could result in a probate issue.
Mm.
And listening to your title company, title rep, using a good title rep that could advise you on, hey, you have this listing, but you're going to be needing probate. Do that before you get under contract. It's definitely an issue that I see where we're under contract and they're ready to close and they realize, hey, we have deceased John Smith on here that we have to clear. And I
Where
can
were you for 90 days? Where were you for 6 months?
what we've been doing for a while, but maybe it's back up the line of title. Maybe I mean when you inherit property and you put 5 kids on title, and then you just sit on it, and one sibling lives in the house for the next 20 years. Well, maybe you don't follow the deed properly, or one of them is titled their 1/5 share into the trust. What has that done? Okay, well, it's severed joint tenancy for their share. So then it's really having a true understanding of vesting and a form of title, and the title presumptions will go a long way to identifying those issues before you get under contract. It's a great fun project for me to try to fix that, but it's going to be really expensive, and it's maybe 50-50 chance the court will agree with me and we can close the deal. Maybe we can't. So that's a place I would really look to hone your expertise and use your resources with a good title company is probably a good start. And then once you start working with an attorney, I think a thing that would go a long way is humility. Honestly, if you haven't done a probate sale, don't sugarcoat it and tell me you have, because I'll learn pretty quick whether you have or not. If you come tell me you want to do a 7-day close through a probate administration, you clearly don't know about your notice of proposed action you're going to have to do, and maybe that's an issue. Maybe it's not, maybe it is, but being honest with the attorney that says, hey, I've never done a probate sale, I have this listing, I think it's subject to probate, what should I do? I'm glad to work with the agents to teach them the process, or what do I need from the probate side and what do you need from the real estate side. But if you're coming in trying to bloviate and posture that you know what you're doing in probate, you better know what you're doing in probate, because you'll be exposed pretty quickly if you haven't. And so humility and working with your resources to truly trust your title reps is probably the 2 biggest areas I'd suggest.
If I'm in a little pain over this discussion, it's because I'm living one where I had a client and we had one piece of property and then we had another one, and it was subject to litigation as well as probate. and appellate litigation. So you have years and all kinds of documents. And I went with a new title company, hoping they get better service, and they told us we're good to go. And here we are ready to close. And I guess because the dollar amount they have somebody else underwrite the file. Oh, gee, we need 2 belts and 3 suspenders on this outfit. And next thing you know, and my attorney's pissed, rightfully so. I am too. So I don't know. Are you able to? Is there a particular title company you work with? Do you want to give a plug to a particular title rep or title company that you feel particularly comfortable with? Or are they all kind of the same? They're all kind of like good days, bad days, good files, bad files. Who the hell knows what you're going to get?
Yeah, ultimately, most of the big title companies use the same underwriters.
Yep.
So you're going to end up with the same ultimate underwriting attorneys that you're dealing with. I don't want to name names and lose business from somebody else that doesn't get mentioned, but my people know who they are, and I use them pretty regularly, and they end up sending me quite a lot of business, so I appreciate them. But if you're a title rep looking to grow your book of business, marketing with probate attorneys is a great idea as well. It's a great reciprocal relationship with the title agent and the probate attorney. I get more business from title than I do from real estate agents, because they're the ones that see the problem, and they're advising their agents, hey, this is your problem. This is my probate guy to go to. And so the probate attorneys, I recommend them getting to know the title reps. It's a great place for a probate attorney to build their book of business. And it can be a very symbiotic relationship, both with the real estate agent and the title company.
Good to know. I know that in LA County, the top probate attorneys by volume, by far their business more comes from realtors than goes out to realtors, right? That's their source of business for the most part. I've never heard anybody talk about title, and I've always tried to get in with the companies. I just find they have a select group of people they work with. They're a tough nut to crack. So, and rightfully so. So kind of last question I have now, anybody else on the call here, if you have a question, it's funny, I don't see any. I don't know if that means you guys are mesmerized by my discussion. I'm enjoying myself. So
I don't know.
What percentage of your workday are you in court now? And how is that different or the same as the percentage you were in court pre-COVID?
Well, you mean making virtual appearances versus in-person appearances? That
in person, I think, what percentage of time do you still today make? You must go in person, I imagine, for actual hearings and actual trial, because you're a litigator more so than the average probate administration attorney. So I'm just trying to get an idea of how less often are you in court than you used to be?
I'm in court. If I have a hearing, I'm going to be in person. Our office, it's literally like my curtains were open. You could see the building. It's as close as possible in San Diego. My out of county, obviously, I'm not driving up to Riverside or LA for a case management hearing or whatnot. But our office is our protocol is, if you can be in person, go in person. So we're there in person in the courtroom almost every time. It's a lot easier to build a rapport with the court, especially in San Diego with the turnover in the judges. It's pretty important to build that reputation and have that face time with the court. So we're really in all the time. Our office, our attorneys are in person. I mean, I think we had 6 hearings today across our department. So it's a lot in person. I do not enjoy the virtual appearances. It's hard. It's the tech always gets in the way. There's some sound issue, or you're echoing, or somebody wants to talk at the same time. So it's just a lot easier to be in person. So we're in person.
I remember your desk used to be set up where we had a view out the window inside the actual courthouse, right?
I got a little bit bigger office, so
good for you. Good for you. So I do, and I would say to anybody on the call, as a real estate agent, we don't often have to go for court confirmations. You don't have to, but I would say, why would you not? What a great chance to learn and give better service to your customer being there in person. And on the buying side in court, I've won at least 2 cases or 2 properties for investors in the last 2 years. Otherwise, I wouldn't have got paid on, because I heard things the judge said that the party online, for whatever reason, weren't paying attention or were distracted or something happened. but we got the property. So I definitely urge all real estate agents, when you have a chance to go to court, go. Even something that's routine, go and learn what routine looks like. I think, as a probate administrator, you're not going to go to these, but like the letters of authority are pre-approved, and the judge is just going to, as a matter of course, read the case. If there's no objection, approve it. I tell the real estate agents, go anyhow. Yes, it's routine, but go learn what routine looks like so you can tell your customer that they don't need to show up, or they can, and here's what you should expect is going to happen. So I really admire that about you guys. I know we had the same discussion last time about that's why you're located there, and of course, being litigator, it's a little different than administration, but I think that's a big advantage that you're offering your clients, being close.
Well, you present different. It's a lot. You have a different. Once you've done it enough, you have a different confidence in court. You're not hiding behind a computer screen, so it's. Right. It is easier. Court confirmations are fun hearings, guys. If you have a court confirmation hearing, it's kind of auction house-esque with pounding the gavel. So it's kind of fun experience to see those anyways.
Yes.
But to see the court, to see probate, at least in San Diego County, it's not scary. It feels like it should be for your clients. But if you've gone there enough and you can tell them like, hey, this is how it works, it's really not that intense of a process. It may give them a little bit more peace of mind going into it, especially if your clients are heirs. If you have heirs as the clients, they're dealing with the loss and their emotions of that already. So any bit of peace of mind you can give them on what the process is going to be, or it's going to go this smoothly, it sets you apart from your peers, and it shows that you know what you're doing, and your confidence in the court and the comfortability in the courtroom, not only as an attorney but an agent or fiduciary as well. It just kind of, it shows that it's not that intense of a process. Trial is obviously intense and really scary, but most of these routine hearings, pre-approval, or even court confirmations are pretty straightforward processes. And I don't know, maybe I'm weird, but I find them enjoyable. So.
I think it's exciting. It's like a game. It's fun. And I like to meet the customer. In LA County, there's like a little coffee shop on the second floor. And I said, well, meet me there and I'll walk you to the courtroom just to make them feel more comfortable, because it's very tense. There's a lot of tense people in one room. Not a lot anymore, but there's a number of tense people in the room. And if you're the one that's calm, you're going to be the person that's going to help your customer get through the process. So I would encourage anybody on this call, if you have an opportunity to go to court in your local county, go and come back and share your experience. I'll say this. I've given this advice a couple hundred times. I've never had anybody tell me they regret going. I've only had people come back and say, I learned a lot. It was a great experience. And that's how I built my business, going to court every day. So I would encourage you all to do that. Well, look, Zach, I know at your hourly rate, I can't afford to go much longer. No, it's the end of our hour. I really enjoy talking to you. Thank you so much for the time you spend and being willing to educate us. I just can't thank you enough. I really appreciate the time we spent today and being on here. So thank you and welcome back.
Thanks for having me. Anytime you want me, I'm here.
And for the rest of you, our guest today was an attorney from San Diego, California. Antonio and Miranda is the law firm, and expertdivorcelaw.com is one of the domains they have, and the other one is antoniomiranda.com. And they handle divorces as a big part of their business. But as he mentioned, Zach is the head of the probate litigation and estate litigation department. They also do estate planning in the San Diego area. Please feel free to reach out to them, and there's a contact button right on the website. Or if you need some help there, reach out to me. I'd be more glad to connect you guys. So again, Zach, thank you so much. Everybody else, probateweekly.com if you want to come on the Zoom call. Past episodes, go to episodes.probateweekly.com. Appreciate the likes, subscribes, comments. Was this helpful today? Did you learn something? What would you like to learn on that? And we'll see you guys next Thursday at 4 p.m. Thanks so much. Zach, thanks again.
Thanks, Bill.